propriedade intelectual é responsável hoje por até 80% do valor das empresas. Mas isso não acontece apenas porque as empresas dão valor à sua propriedade intelectual. A propriedade intelectual vale muito porque a sociedade dá valor ao esforço de solucionar seus problemas e de lhe criar oportunidades. Nosso congresso desse ano vai reunir especialistas em propriedade intelectual, juristas, economistas do desenvolvimento e da inovação para nos guiarem nessa importante discussão. O pano de fundo escolhido não poderia ser melhor: as maravilhas da cidade do Rio de Janeiro. Para comemorar seus 60 anos de existência, a ABPI reunirá os participantes nos mirantes deslumbrantes do Pão de Açúcar, ícone turístico do Rio de Janeiro, aclamado por visitantes do mundo inteiro. Durante 3 dias, teremos a oportunidade de nos encontrarmos, fazer negócios e, sobretudo, de discutir e aprofundar nosso entendimento do papel da propriedade intelectual frente aos desafios brasileiros. Da consolidação do agronegócio ao desenvolvimento do turismo e de indústrias avançadas, da transformação digital e da transição energética ao estímulo ao empreendedorismo e à inclusão social. Participe e se engaje com o compromisso social do Congresso da ABPI de 2023. Esperamos vocês de 20 a 22 de agosto na cidade maravilhosa do Rio de Janeiro.
Bom dia a todos. Bom dia aos que prestigiaram presencialmente esse evento, que estão aqui na sede da ABPI em São Paulo. Quem está assistindo pela internet, seja muito bem-vindo. Vocês não podem ver, mas temos cerca de 800 pessoas aqui na sede da ABPI. É um sucesso extraordinário aqui, né? Muito obrigado pela presença. Como vocês sabem, esse evento vai ser em inglês, sem tradução simultânea. Vou aqui só fazer a abertura e vou deixar vocês com os nossos palestrantes de hoje. Vamos receber hoje uma convidada muito especial, a doutora Karin Friehe. Não é doutora? You know, we have the custom in Brazil. Anyone who's a magistrate or even a lawyer, we call them doctors. But you might not be a doctor academically, but we know that you are a doctor in your knowledge and your experience. Mrs. Friehe was presiding judge of the 6th Patent Nullity Board of the German Federal Patent Court from 2016 until she retired in the autumn of 2021. She was a member of the Federal Patent Court since 1998, where she acquired expert knowledge in proceedings concerning actions for the declaration of nullity of a patent, as well as in appeals concerning patent, trademark, utility model, and plant variety cases. She studied mechanical engineering at the Technische Universität in München, a pre-diploma in medical engineering, 1976, and she also studied law at Munich University. First state examination in law, 1980. Having passed the second state examination in law in 1984, she entered public service as a prosecutor in Munich. Since 1990, she has been a judge, first at Munich District Court, and since 1998 at the Federal Patent Court. From 2003 to 2005, she lived in Moscow, Russia, where she implemented a project funded by the European Union with Rospatent, the Russian IP office. Since then, she participated in different European Union-funded projects in Russia, Tajikistan, Bulgaria, Jordan, Turkey, Azerbaijan, Serbia, and Egypt, and also participated as a speaker in different international conferences. She was a lecturer in training courses for future patent attorneys and in training courses for attorneys at law to obtain a special qualification in the field of industrial property, as well as one of the deputy presidents of the Examination Board for Patent Attorneys in Germany. Muitos de vocês não sabem, mas para ser advogado ou ser patent attorney na Alemanha é muito complicado. E a doutora Friehe tem experiência também em treinamento desses profissionais. Muito bem. E quem nós convidamos para aqui participar como debatedor com ela e que vai fazer o contraponto em relação ao sistema alemão, apresentando o sistema brasileiro, é um dos maiores especialistas brasileiros, conhecido de todos, que tem a honra de quem tem a honra de ser amigo desde a década de 80, quando fomos contemporâneos, na Faculdade de Direito da Universidade do Estado do Rio de Janeiro. Contemporâneos porque ele, muito mais velho, estava à minha frente, mas chegamos a ter uma intersecção de tempo. Dr. Jacques Labrunie, sócio de Guzmão e Labrunie Advogados, é sócio fundador do escritório, coordena as áreas de contencioso e de patentes, representa empresas nacionais e internacionais em diversos setores, como farmacêutica, eletrônica, tecnologia, automotivo, alimentos e bebidas, agroquímico, químico, entre outros. Ele é conselheiro da ABPI, tem a honra de participar do nosso conselho diretor e nos auxiliar na ABPI. É professor doutor de Propriedade Intelectual e Direito Comercial na PUC de São Paulo, desde março de 1991. Estudou, como disse, né, na graduação na Universidade do Estado do Rio de Janeiro, mas fez seu mestrado na Université Panthéon-Assas, Paris II, fez seu doutorado na PUC de São Paulo. Muito bem, vou passar agora aqui a palavra para a doutora Friehe, que vai começar a sua exposição. Peço desculpas, vou ter que me ausentar aqui para outra sala, que está ocorrendo uma reunião com o INPI, para a qual a ABPI foi convidada. Vou ficar indo e voltando aqui entre as duas salas, e passo também, então, nesse momento, a condução dos trabalhos ao Dr. Jacques Labrunie. Muito obrigado a ambos.
Bom dia. I'm sorry I don't speak a lot of Portuguese, and anyway I don't speak Brazilian Portuguese, a bit of Portuguese. I'm very honored that you are interested to hear what I want to tell you about the Federal Patent Court in Germany and the work in the patent nullity boards, proceedings and patent nullity in Germany. I would like to start first with the German Federal Patent Court. So I have to, yes. I have to go to the different slides. The German Federal Patent Court was only established in 1961, so it's younger than I am. It was not planned before 1961. Any appeals against decisions of the German Patent Office, then it was only called Patent Office, it's only German Patent and Trademark Office since the end of 1998. Before the Patent Court was established, the appeals went to appeal boards in the Patent Office, and so if you were not satisfied with the decision of a department or of an examination in the Patent Office, I don't know what's this. If you were not satisfied, you could appeal, and the appeal would go to the appeal boards within the Patent Office. One woman was not satisfied with their decision in an appeal regarding costs. And there is one thing that she remembered, and this is that in our constitution we have a provision that says that anybody who feels himself negatively affected by a decision of the administration may go to a court. There must be a court where he can go to. And she said the appeal boards and the Patent Office don't have the quality of a court. She was right. The courts gave her a yes. And so any decisions of the appeal boards would have been subject to an appeal to Munich Administrative Court, because the Patent Office is situated in Munich. So the Munich Administrative Court would have been responsible. And you may imagine it's not only about costs, but also technical subject matter of patents. And the Administrative Court was not fit for this, so the legislature founded another court, and this is the Federal Patent Court. It started to work in 1961 only. it's really a very young court. The court is competent for questions of the validity of a patent right, of a trademark right, of a design right, etc., and plant variety right. So anyone who feels affected by a decision of the examination boards or the registration boards in registration division in the patent office can appeal to the German Federal Patent Court, and the validity of the right will be tested, will be decided upon. What we have in Germany, and I read that it's in a similar part in Brazil too, we have a bifurcation system. So we have infringement courts and we have the patent court. The infringement courts are responsible for infringement of intellectual property rights, industrial property rights, and they have to assume that, for example, a patent is valid. If the validity of the patent is in question, you must file an action for the Federal Patent Court. I heard that you have something similar in Brazil, but I suppose I will hear about it more later. I have to check. I'm sorry, I have problems with my eyesight at the moment, and so it's sometimes a bit difficult. I have to get the paper a bit closer. The Federal Patent Court is competent for the Federal Patent Court is competent for validity. The civil courts are competent for infringement, but there is one court where everything comes together, and that's the Federal Supreme Court. For example, for patents, it's the 10th Civil Board of the Federal Supreme Court that is responsible for infringement and validity cases of patents and utility models. There, everything gets together again. So we have one board that is responsible for everything. In the German Federal Patent Court, we have a specialty. We not only have lawyers as judges, but also technically qualified judges. The lawyers we have to fulfill the qualifications that every judge in Germany has to fulfill. So we have to study law, have to have studied law, have to have passed both examinations, and if you want to be a judge in Germany, you must be quite good in your examinations, because otherwise they won't take you. The position at the Federal Patent Court is not a position for beginners, because in the framework of the courts, the Federal Patent Court is not first instance court. But it's equal to higher regional courts, and they usually are second instance. So usually when you are a judge at the Federal Patent Court, you have been either a judge at a district court or at the local court before, or you have been an examiner, mostly a trademark examiner at the German Patent and Trademark Office. But then we also have technically qualified judges. They are real judges. They are not court experts, but they are judges who sit on the bench. They are either scientists or they are engineers, and they all have been patent examiners before they were appointed judges at the Federal Patent Court. So in my board, at the end in 2021, I had one lawyer who was my deputy and 10 technically qualified judges. They were all physicists or electrical engineers, because we had information and communication technology as a subject matter of the patents we had to review. We also had a part of the medical medical instruments, medical technology patents. The technically qualified judges participate in boards where their technical knowledge is important. So they are not members of trademark boards of appeal. They are members of technical boards of appeal and of patent nullity boards. And the technical boards of the people from the technically qualified judges from one technical board of appeal are also members of one special paternality board. So at that time, now it's usually one technical board of appeal. At that time, when I was still a presiding judge, we had two technical boards of appeal, respectively the judges, the technically qualified judges from two technical boards of appeal, the 18th and the 19th, and they all, as I said, they were all electrical engineers and physicists. What is really important is that these technically qualified judges are professional judges. They are not court experts. They have the same voting rights as I have. As I had, now I have none at all. But at that time I had. So we decided in the judgments in a composition of 2 lawyers and 3 technically qualified judges, and the technically qualified judges could decide, of course, upon any legal question too, and as well as we could decide upon the technical problems. So it's a board. We were 5 people, and those 5 people have to make up one decision. And to be honest, without saying too much about deliberation, secrecy, usually we were unanimous. So it's not really a very big problem, because we talked about all the problems. We talked about the legal problems, we talked about the technical problems, and mostly we came to one solution. We had to come to one solution, but not to a unanimous solution, but mostly we had a unanimous solution. Sorry, and we have 7 patent nullity boards and 16 boards of appeal in different matters. And as I already said, the court has a position like a higher regional court. So now I have to find the right slide. I think it's this one. This is the next one, isn't it? I cannot see it. The problem is I cannot see it because my eyes are so bad. Cannot read. I can only see it's a small text on it. I'm in 5. 5. Is this okay? Okay. Okay. The German, as every court in Germany, the tasks are attributed to the special boards by the presidium, as it is called. The presidium is composed of the president, and in the case of the Federal Patent Court, this depends on the size of the court, by 10 judges and presiding judges that have been elected by the judiciary of the court. So it's some sort of self administrability or something you would say. That's what I already said, and now I have to find the next page. the way how the work is divided between the boards in patent matters is based on the IPC classification, International Patent Classification. The subject matter of the patents belongs to a special class, IPC class. And a special class, or special classes, of course, are attributed to one technical board of appeal. And the judges from this board with their specific IPC classes are attributed to a patent nullity board. So we had the judges from the 18th and the 19th Board of Appeal as technical members of the 6th Patent Nullity Board. And the subject matter of the patents was that was defined as belonging to the 18th and the 19th Technical Board of Appeal. So in this way, we were responsible for specific IPC classes. But then, as I told you, we were altogether 12 judges in the board, and one lawyer and me, and all the judgments have to be done by 2 lawyers and 3 technically qualified judges. Now we have 10 technically qualified judges, and there we had to make a plan at the beginning of each year for which IPC class, which technically qualified members of the board are responsible, because in an abstract way, every case, every patent that should be reviewed as to validity had to be attributed to a special group of judges right before it entered the court. In Germany, they are very strict with this. And so in the beginning of each year, we made a long list which judges were responsible as rapporteur and as the 2 other sitting judges that have to decide together with the 2 lawyers about the validity of a patent. So you have to be able to find out from the schedule of the cases, from the schedule of the IPC classification, and the schedules drawn up by the Presidium and by the internal schedule of the board, Patent Nullity Board, who is responsible for this case. Next slide, please. Okay, in patent nullity board, the presiding judge always is a lawyer, and his or her deputy is a lawyer too. So there are 2 lawyers, and we have those technically qualified judges in our board, in addition to those. As I already said, in 2021, in my board, we were 12 persons. I had a deputy who was a lawyer, who is a lawyer, she still is, and 10 technically qualified judges, which is quite a big board. We had a lot of cases to work upon and a lot of work. And the oral hearings and the judgments are done by 5 judges, the 2 lawyers, and 3 technically qualified judges. Next one, please. I think it's 8 then, isn't it? Okay. Now I turn to patent nullity cases. In patent nullity cases, we have actions. We don't have appeals, we have actions, which is a very refreshing thing for an ex-civil judge as I was, because in appeals you have you have only appeals. It's not really, you don't have a judgment, you have a decision later, but it's not a judgment. So finally, after some years at the Federal Patent Court, I finally had to work upon actions again. The action has to be written, of course, and it is a popular action. So everybody may file an action for the declaration of invalidity or of revocation of a patent, except as it's a controversial proceeding, the patent right holder himself may not file an action against himself. So it must be somebody else, not the right holder, not the legal successor of the right holder, and not somebody who has signed up that he will not contest the validity of a patent. That sometimes is done by licensees. Licensees sometimes have to sign in the license contract that they will not attack the validity of the patent. And the defendant in patent nullity cases is always the person who is registered in the register as the patent right holder in European patents as a patent right holder for Germany. If sometimes in European patents, after they are granted, they develop into different parts, and different owners may be the right holder in different countries. So in Germany, the defendant in a patent nullity case is always the person who is registered in the register as the patent right holder for Germany. Next one, please. The first thing that we have to check when we get the action into our board, which is done by people in the receiving section of our board, of our court, they send it to our board, and what is important is that the action is admissible only for different patents, in particular German patents, German national patents, and European patents with effect for Germany. And we only may invalidate them with effect for Germany because our competence ends at the territorial borders of Germany, in patents at least. It's also a supplementary I don't remember the name. Supplementary protection certificate. Thank you. Supplementary protection certificate can also be attacked with a patent. What we still have in our patent law is we also may be responsible for German democratic patents, but as the German Democratic Republic ended to exist in 1990, you can imagine that I don't think there are any more cases. Anyway, if the patent is valid, everybody may attack it. But if the patent is not valid anymore, there might still be an infringement case pending before an infringement board, in an infringement court, in a district court, or in a higher district, higher regional court. Then it might be important if the patent is valid or is not. So a person who is affected by such an action in an infringement court may, of course, contest the validity of the patent, even if the patent has expired. But he has to have a legal interest in declaring the invalidity, the revocation of the patent during the time when it existed, because the infringement is only important in the time when the patent existed, not in the time when the patent has already expired. So in the infringement court, there might be, like, for example, a patent was granted in 1990, or was applied for, not was granted, was applied for in 1990. You have 20 years, which means it's 2010. And there might still be, so it expires it expired in 2010, but there might still be an infringement proceeding pending, maybe decided upon the district court, the appeal decided by the higher regional court, and they give it back because there were important flaws in it, and they say, okay, back to the district court, etc. And so it might take some years, and suddenly the questions comes up if the patent it's valid, and so the person who is called the infringer in the district court or in the higher regional court or even in the federal Supreme Court may start an invalidity action even if the patent has expired some years ago. But this is only for somebody who has a legal interest, and not anybody. For anybody, the action in a patent nullity case is only if the patent is still valid. Okay, here I have the action in concerning the validity of the patent must attack the patent as a whole or parts of the patent, but it must be parts which can be separated from the rest. So you can't just attack a single word in a claim or so. So it must be a separate. It must be possible to separate it. But you might, for example, claim the invalidity of one of the claims. Sorry, of one of the claims. As I said, the patent nullity action must be in German, which means the action, the paper sent to the court must be written in German. But sometimes, or even most times, in our case, there were very few German patents or patent applications as a state in the art in the case. And so there might be American or American patents in English language, or French patents, or even we had a Russian patent once, or sometimes Japanese or Chinese patents. Japanese and Chinese we ask at least for an English translation, but otherwise for Russian also we ask for a Russian translation if we need it. But English and French documents that are cited as state in the art were usually not did usually not have to be translated into German in our court. We are free to ask for translation, but well, we are free. We don't have to ask for a translation. Only the action itself has to be in German, because German is the court language. In Germany, but that's something that's special in Germany. It's not in all the countries of the European Patent Convention. A patent, either a national patent or a European patent with effect for Germany, is only it can only be attacked by a nullity action if no opposition is pending or possible. So if there is an opposition pending, for example, before the European Patent Office, for the boards of appeal of the European Patent Office, even if it's a an opposition which was filed by somebody else. As long as it's pending, you cannot file for nullity in Germany. But what you can do is you can enter the case before the European Patent Office. Okay. And then something very important. Usually nobody who is not affected by the patent does claim invalidity. Why? Because an invalidity action is a very, very expensive thing. So a patent nullity case that has been filed for the for the German Federal Patent Court has to be given a value. The value of the case is the value of the patent, so we have to fix right at the beginning the value of the patent, which we estimate, and according to this, out of a list. As an annex in our patent cost law, the fees for the nullity action are calculated. They have to pay these fees within 3 months of being served the decision, how much the value will be, where the value is, and if they do not, the action will be deemed withdrawn. The fees are very high. In Germany, the value of the case, which means the value of the patent, for the fees is a maximum of 30 million, which is sometimes even very low for the value of the patent. Imagine you have a patent which might be €1 billion worth. But for the fees, we have a maximum of 30 million. And if we fix those 30 million, the fees for our instance, only the first instance at the Federal Patent Court, is almost €500,000. So our board had lots of very valuable patents, and I suppose we contributed quite well to the finances of our court. Yeah. I already said that. So now we have number 11, I suppose. Yes. As soon as the fees are paid, the action is served on the defendant. So we wait until we get the confirmation that the fees are paid, and then we can serve. We should serve the action on the defendant. As long as the fees are not paid, the action will not be served on the defendant. And this is important because, as I told you, because of bifurcation, the civil court, which decides upon the infringement action, has to assume that the patent is valid. They cannot state that they think the patent is not valid. So the only thing that they can do is to put on a hold the infringement case. But they can only put it on a hold if there is a patent nullity action pending. And it's only pending as soon as the action was served on the defendant, on the patent right holder. So the patent right holder, so the patent, the assumed infringer, the claimant in the patent nullity case has a very high interest in having the action served as soon as possible on the defendant, which is the patent right holder, because otherwise the infringement case cannot be put on hold. After the action has been served on the dependent has, from this date when the action has been served on him, he has 1 month to declare that he will oppose the patent nullity action, and another month to bring grounds forward. So it's only 2 months after he has been served the patent nullity action. This can be extended up to 1 month. Years ago, it was much longer, but the problem was that what follows from these declarations is an indication. I will come back to this. And if this takes so long, the infringement courts cannot rely on this, and the infringement courts had to go forward. There was their judgment in the first instance, and we hadn't worked on it. So they wanted to speed up the procedure, and now the patent attorneys and we have to be very fast. We can fix a date until when the parties may file anything which we put into our preliminary indication, but then this indication should be sent to the parties within 6 months of the serving of the patent to the defendant, and this is a very short time. If you think that 5 people in the board should read the files, and the files are sometimes really fat. We were used to have more time. When I took over the 6th Board of Appeal, I thought that 2 months should be sufficient. They had 1 month for declaring if they want to oppose the patent nullity action, and when they opposed it, I set a time limit of 2 months. For the answer, and they cried, we cannot do this, because they were used to do this within 4 months only. And once I had somebody who wanted another extension, and he had already had 7 months, and he wanted another extension for 2 months, and I said, you can make a baby in 9 months. So it should be sufficient. It should be. And the experience as an old lawyer, as an old judge, is what they cannot write down in 6 weeks, they cannot write in 6 months anyway. It's very rare that it's different. Next one is number 12. Pardon? Okay, I rush a little bit. Okay. But I think the other ones are not so long anymore. And anyway, most of it will be the same in Brazil. We have to send an indication. Sorry, I didn't know. We have to send an indication within 6 months of the date of the service of the action to the defendant. That's what I already said. That indicates what the board thinks about the case now. And we set time limits in this indication up to which date the parties may answer may bring forward new attacks and new defenses. And if they don't do, we can say it's too late. You cannot go on with this. Okay, we go to numbers, and this indication is very important. So next, please. If means of attack or defense are duly rejected by the first instance by the Federal Patent Court, they will be rejected by the Federal Supreme Court too. And if you are the defendant and you didn't bring forward in time your defenses, your client may lose his patent just because of this, and he may lose his patent in both instances. Next, please. Nullity proceedings in Europe are in Germany very similar, usually in every state, very similar to the national patents. Nullity proceedings are in the competence of the national courts regarding of the patent, and only for the patent within the territory of this country. So, of course, we may only invalidate the patent for Germany. The national court will only revoke the European patent with effect for the territory, of course, and the grounds for declaration of nullity of a patent are the European grounds and the European Patent Convention for the European patents too, but the procedural law is German. So this is different. So the matter of the law is European in Article 137, I think, and the procedural rules are the German rules. In Germany, mostly all of the patent nullity cases concern European patents now. I think in my board it was more than 90%. Next one, please. I listed up the grounds for nullity or revocation. They are probably the same in the European Patent Convention and the German Patent Act. I listed them there. What is important, I don't know if you have this. This is for the whole of Germany, of the whole of Europe. We have practically the same grounds for revocation in the whole of Europe. What is different? We don't, for example, we don't have patents for business methods like they have in America and the USA. So this is the list. I don't want to read, just the list. And I will come back to each of them. Next one, please. It's very similar with your I suppose so. I suppose so. It's yeah, yes. And this is only these grounds for revocation can be invoked in a patent nullity case. No other, like for example, missing unity or something like that. It's not a ground for revocation. Now I just come to the specific grounds. I suppose it will be the same with you too. We have a subject matter that is not considered as inventions, which I listed there. I don't want to read it to you. I suppose you will get the slides anyway. Important is that it's only considered. They are not only not considered to be an invention if the patent application only relates to the subject matter as such. Of this. Next one, please. Computer implemented inventions. The problem with the computer implemented inventions is the question of technicity. We have technicity as a prerogative for a patent. A patent cannot be a patent if it's not technical. And so for computer implemented inventions, we have to check for technicity. And so these are the rules that we have for this. Next one, please. Again. Exclusions from patentability. some inventions are excluded from patentability for plants and animal and plant varieties. For animals and for plants and animal varieties, or anything like that, we have no patent protection. We have a plant variety protection. Then, the next one is very important. Inventions contrary to ordre public or morality. You cannot clone a person. You can clone a person, but you cannot get a patent on cloning a person, for example. What is important is that ordre public and morality is more than just the law. If something is against the law, this doesn't say that it's against ordre public or morality, because the laws can change. Not all laws are stating what is ordre public and what is morality. So you have to check if it's one of these cases cited there, and it's in the European Patent Convention. It's also in the German Patent Act. Next one, please. Novelty. A patent is not novel if the subject matter in all its elements was state of the art at the priority date. I suppose it's the same as you have. Yeah. So I'll go on to the second next, because next one is for novelty too, and I suppose you really have the same. Oops. What is the most important thing in patent nullity cases in Germany is the inventive step. If you take into account if you take into account what the person how would say it? A person who knows the person's skilled in the art. The person skilled in the art knows, and he doesn't have to combine more than 2 or 3 parts of the state of the art, and he will probably not have to use inventiveness to come to the subject matter of the patent. I suppose this is the same in Brazil too. Yeah, okay. So I will go on to the next one, because I didn't know that I had to finish at 10 o'clock. Sorry. Sorry. The next one is industrial application. The patent has to be industrially applicated. It has to be possible to bring it to industrial application. It's very rare that it is not. There are 2 cases. First, it's not industrial application at all, nothing industrial. And the second one is it's no use for anything. So no industrial application. The next one is insufficient disclosure. I suppose you have the same in Brazil? Yeah. So the person skilled in the art must be able to, if he works upon the description, to come to the same result. Next one, please. Extension beyond the contents of the application as filed. You know that it's a priority. A patent is a priority system, so you shouldn't get a patent for something that you did not disclose on the priority date, and that's why the subject matter of the patent may not be extended to over the borders of what you applied for at the priority date, and this is the extension beyond the contents of the application as filed. There is another extension, which is, next one please. the extension of the scope of protection of the patent. Sometimes it happens in opposition proceedings or in previous patent nullity proceedings that the patent is not made smaller but made bigger, and so you should not get protection for something that you did not get when the patent was granted. So that's. Okay. The problem is somebody should not infringe the patent as it was granted because later it was enlarged. Because you cannot, it's not allowed to enlarge a patent after it was granted, and this is the extension of the scope of protection of the patent. This is not allowed. Okay, next one, please. Yeah, that's what some people call theft of the patent. The proprietor of the patent is not entitled to the patent. It's not the inventor or the person or the person to whom the patent subject matter belongs. It's somebody else, and somebody else got knowledge of this and applied for a patent in a fraudulent way, for example. And so in that case, the right holder, the right patent owner, can decide if he wants to have the patent nullified or if he wants to file an action before the infringement courts that the patent be transferred to him. Next, please. Yeah, what I already said, there are no additional grounds for nullity. These grounds for nullity are fixed. Nothing else is possible to bring forward as a ground for nullity. But I think all this, what I rushed through right now, is more or less the same in Brazil. What we have now, next one, is the scope of the decision. This is something special for patent nullity proceedings. The court may grant to the claimant less than he wanted, but not more. We are bound by the limitations of what the patent nullity claimant asked for. If we find that that the patent is not fully to be invalidated, that the cited grounds for patent invalidation are not valid for the whole patent, we may partly reject the claim. Like, for example, we say the patent will be partly invalidated as the patent claims are now, and then we have narrower patent claims, or as patent claim number 5 is invalidated, or something like that. And if we find that the patent is valid, we will reject the invalidity action. Yeah, we also have to decide upon the costs of the proceedings in patent nullity cases. In appeal cases, it's not mandatory, but in patent nullity cases, it's mandatory, and we have to decide upon the preliminary enforceability of the decision. The preliminary enforceability as about patent nullity is only on costs. So if we decide, for example, the claimant bears 40% of the costs and the defendant 60% of the costs, they must be able to preliminarily enforce this decision before the Federal Supreme Court decided finally. Yeah, there was something I wanted to tell you in connection with the indication. Years ago, there was no indication. It was only it entered into the law for all actions that were brought to court after the 30th of September 2009, as far as I remember. Before, there was no such indication. There were no such time limits where we could reject any new things. So most of the parties just looked what they got from us, and then started the case anew before the Federal Supreme Court. And we took one year for our cases, and the Federal Supreme Court took 3 or 4 years. They don't have technically qualified judges. They had to give everything to a court expert, and I think you know how long it takes if you have to find an expert to do things, and until you get his statement. So they thought about what to do, and they invented this indication. At that time they said, oh, it's not much more work for the Federal Patent Court. In fact, it's about 50% more work, because often the case starts anew after the indication. Because when we say how we see the case, they start finding new things. It's 50% more work, I suppose. Yeah, but back to what I just wanted to say, the defendant may defend his patent as a whole or in amended version, but this amended version must be narrower. As I said, he cannot extend after the patent was granted. So, he is limited by the whole of the patent. He can say I want the action dismissed, and I defend my patent as it is, but he can also bring amended claims. But as I said, the amended claims have to be narrower than the patent is as granted. Yeah, and I think the next one is, thank you very much. I hope I was not too fast in the end, but I think in particular the grounds for revocation or for invalidity are more or less the same as I understood in Brazil and in Germany and in Europe. Thank you.
Thank you very much, Ms. Friehe. It was very, very interesting. We apologize for the limit of time. It's a lot of subjects to be discussed, but it was very good because at the end, the grounds for nullity are very similar in Brazil. So it was much more interesting seeing what was different, what is different from the beginning, that we have a lot of differences in Brazil. So thank you very much. It was very interesting. I will show a little bit on the Brazilian system, summarized version of the Brazilian system, just to have the differences with Germany, and then we have the questions from the people and the doubts, okay? And I would say some words in Portuguese just to welcome the people, okay? Então, novamente, bom dia a todos, obrigado aí pela participação dos que estão aqui presenciais e todos que estão online. Espero que vocês tenham aproveitado aí a apresentação do sistema alemão, que é bem diferente do nosso em alguns pontos e bem similar ao nosso em outros. Então, eu vou fazer uma apresentação rápida em inglês do sistema brasileiro, para a gente fazer a diferença com o sistema alemão, e depois abrir para as perguntas, e as perguntas podem ser ou em inglês direto ou em português, e eu traduzo, tá? Fiquem à vontade aí, por favor. Então, por favor, pode colocar a minha apresentação. Ah, tem um passador aqui, né? Just a general overview, then we have, as in Germany, we have two systems. We have the patent infringement and the patent nullity in different courts. So we have the federal courts for patent nullity and the state courts for patent infringement, the civil state courts. So, and then we have for the patent nullities, the federal judges and the Federal Court of Appeals. But at the end, as in Germany, we have a state, no problem. You have the Superior Court of Justice and the Supreme Court for Constitutional Matters that are the same for the state courts and the federal courts. And different from Germany, all these courts, we have judges with law background and no technical background. The advantage that we have from certain time now, it's quite recent if we talk about history, is that we have some specialized courts for the nullity cases and for the patent infringement cases. But the specialization are not only in patents or not only in intellectual property or industrial property. They are more broader, but But we have in Rio 4 specialized courts for patent nullities and other subject, and 2 panels at the Federal Court of Appeals in Rio specialized in industrial property. And in we have some specialized courts for commercial or some issues related to the commercial law and industrial property in São Paulo, Rio, and Rio Grande do Sul. So it's coming to have more specialization, but it's still a matter that it's judged by judges with law background and civil courts as a general matter. So it's just an overview, but it's a lot of things here. Similar to Germany, we have the initial complaint. We have, I think that we are missing now it's different what you are showing there. No, it's okay? Okay, thank you. But the main point, as you said, it's that we do not have judges with technical background. So when we came to the discussions on patents, it's very common to have the court expert. So, or the court experts. You can have several court experts or one court expert. This is a problem in general because in some cases we have experts that have a very good background on the technology that we are discussing, but they do not know patent law. So in some cases we have an expert, a patent attorney, and also an expert on the technology, to really understand the patent and the scope of the discussion. And both parties, the plaintiff and defendant, or all the parties, if they are more than one plaintiff and more than one defendant, they also indicate and nominate a court expert and to help the court expert. So it's a little bit expensive and time-consuming, but you can have several experts in one case. But the experts, they give just some information to the judge, and it's up to the judge to decide. Even in a nullity case or in an infringement case, it's up to the judge to say the law. So it's up to the judge to check the patent and check the technology. We have in practice several cases that the experts conclude by infringement or conclude by the nullity, but this is not the most correct way. The most correct way shall be the expert giving information to the judge, and it's up to the judge to decide. So it's similar in also the nullity actions and infringement actions. The proceeding is also the same, with some difference that we will mention here. So for the litigation on patent nullity, the plaintiff may be any party, and even the BPTO. So according to what you showed us, Ms. Friehe, we do not see cases, or you can explain later, if it's possible for the German Patent Office to start a nullity action. No, she's saying no. So this is something that it's different in our system. So the Brazilian Patent Office, if they realize that there is a mistake in the granting of the patent, they are allowed to start at any time during the validity of the patent a nullity action. And we have some nullity action pendings started by the patent office. And on the other hand, the defendant is the patentee, as you said, the patent owner, and also the patent office. So, and for this reason, according to the Brazilian system, is the reason why the nullity actions are filed before the federal courts, because the Brazilian Patent Office is a federal entity and must be sued before the federal courts. So, in all cases, so the defendants are the patentee and the patent office. And the courts are the federal courts, as I said, and we have 4 specialized courts in Rio and 2 specialized chambers or panels for the appeals in Rio. Why in Rio? Because the patent office is in Rio. So the patent office has legal headquarters in Brasilia, but it's actually located in Rio. So the majority of the patent nullity cases are in Rio. And so but it's up to the plaintiff to choose the venue within the federal courts for Rio, for the PTO, or if the patentee is located in another city of Brazil, it's possible to sue in the federal courts in São Paulo, in Paraná, in other places. But the majority of the cases, in view of the specialization, are in Rio. And also another point that you mentioned in your presentation, it's possible to file the nullity action as long as the patent is in force. And according to some decisions in Brazil, it's not possible to file a patent nullity action if the patent is expired, even if the plaintiff is answering or is a part of an infringement action. So it's in some cases difficult. According to some scholars, it must be an exception for this rule, as in Germany, but there are some discussions and some decisions in this sense in Brazil, and some of them still pending at the Superior Court of Justice, allowing or not someone to start a court action after the patent expired. As a matter of fact, if there is no infringement and no allegation of infringement, there is no interest in filing a nullity action after the expiration of the patent. But if there is an infringement pending action, it's still an interest for sure. So these nullity actions are also filed in several cases against infringement accusations, or to avoid infringement accusations in several cases. This is a general overview of the nullity. And the patent infringement, so they are the plaintiff is the patentee. In some cases, it's possible to be the licensee if the license is duly recorded at the PTO, and if the licensee is allowed by the license agreement to start court actions or to enforce the patent. So can be the licensee, but normally it's the patentee. In some cases, both the patentee and the licensee. It's very common the licensee to be the local subsidiary in Brazil, so they are both litigating against the infringer. The defendant, it's one or several infringers, depending on the infringement. And the court is the district civil court. As I said, in some cases we have in Rio, São Paulo, and Rio Grande do Sul, in the first instance, specialized courts in commercial law, dealing with several subjects, in some cases even with bankruptcy and other subjects on company law, bylaws, fights of partners, etc., and industrial property. And in São Paulo, we have 2 specialized chambers dealing with all these matters and industrial property. So it's a little better than 10 or 15 years ago, that just the civil judges were dealing with patents. So we have more specialization and better decisions since 10 or 15 years, or 15 years, yes. So the infringement action can be filed while the infringement occurs, or up to the moment that the patent is in force, or even if the patent is expired, it's possible for the patentee to request damages for the past 5 years. So even if the patent is expired, it's not possible anymore to request the alleged infringer to stop using or producing the patent product, but damages are still allowed for the 5 years, as I'm mentioning here. So it's normal to have the general request or claim from the plaintiff is refraining order to stop infringing, and compensation of damages with this limitation of 5 years that we have in the industrial property law. And we can have in the infringement action some preliminary requests from the patentee to avoid importing, to avoid launching or selling the counterfeit product, to have search and seizure of stocks of products. So in some cases it's difficult for the patentee to obtain these injunctions without hearing the other party, or even before the expert opinion, because as the judge has no technical background, the judge feels uncomfortable to grant a refraining decision against an alleged infringer if there is no clear evidence produced by the court. So it's more common to have these injunctions after the expert opinion or during the proceeding if there is strong evidence allowing the judge to grant these preliminary decisions. So as I mentioned here, we can have these preliminary decisions within the patent infringement pending court action, the cases that I mentioned, and we can have within the patent nullity action also a preliminary decision suspending the effects of the patent during all the proceedings since the beginning, in audita altera pars. It's more uncommon because the judge relies on the BPTO decision granting the patent, that we have a patent that has been examined and granted by the Brazilian Patent Office, but in some cases there is a big mistake, and then if the mistake is proven since the beginning, it's possible for the judge to suspend the effects of the patent between or among the parties involved, or erga omnes, against everybody. And we have different moments that the judge can grant the suspension after hearing the patent office, after hearing the expert, at the moment of the final decision, because even if there is an appeal, the patent will be suspended within the appeal. So we have this general system at the Brazilian Civil Procedure Code that we can use in the patent matters. So it's for sure a question of that the burden of proof is very relevant. So for the defense on the patent nullity, the patentee shall demonstrate that the patent is valid, so with documents, with arguments, with tests, analysis, showing that the corresponding patents in other jurisdictions were granted and are valid. But if, for example, on the contrary, if the corresponding patents in the European Patent Office in other jurisdictions have been cancelled, it's a strong evidence that the Brazilian patent shall be cancelled also. It's not directly decided like that, but it's a strong argument in favor of the plaintiff of the patent nullity. And patent infringement, the defense is to demonstrate that the product or the process does not infringe the patent, and or that the patent is not valid. So this is a huge discussion that we have here in Brazil, still with different decisions at the Superior Court of Justice in Brasilia, that we have this disposition of this provision of the Brazilian law saying that the nullity of the patent may be invoked at any time as a defense matter. So the general lesson of the scholars is that, yes, within a patent infringement action, before the civil court, it's possible to sustain the invalidity or the nullity of the patent as a matter of defense, without the participation of the Brazilian PTO, and it's up to the expert to give information to the judge and the judge to decide if the patent is valid or not. And we have some decisions say that it is not possible to the civil infringement court or to the civil court dealing with an infringement case to decide on nullity, and then the defendant that alleges nullity shall go to the federal court and start a second action sustaining the invalidity of the patent. So, as I said, it's still being discussed at the Superior Court, this matter, with decisions on both sides, and to be really sure the alleged infringer must or shall allege nullity before the infringement action, and then it's more sure to start the patent nullity. But it's a matter that is still being discussed. So I told you a little bit, and I go faster. We have discussed that we have expert evidence. It's very important in both cases in Brazil. It will be very relevant. The judge is not obliged to follow the expert conclusions. The judge can check all the evidence at the case and give his decision, but it's very common the judge following the court expert suggestions or conclusions. And we can have a lot of discussions at the expert proceeding, contesting the nomination of the expert, contesting the queries that have been presented, contesting at the end the conclusions of the expert, asking a second expert proceeding. So it's a lot of work for the lawyers, the expert proceedings, and for the patent experts involved. So we have the final remedies in the nullity, in the infringing action. So the defendant is sentenced to refrain from infringement or not, or the case is not accepted. And in the nullity of a granted patent, as in German, the patent can be considered null for some claims, for all the claims, for one claim. It's a partial nullity is also possible. And we have in the infringement action the calculation of damages with some criteria that we have at the industrial property law, but it's also a lot of controversy here calculating the damages, because it's a new discussion. Even if the infringement is proved, it's a new discussion on how to calculate the damages, how to prove if the infringer shows or not enough evidence of the benefits. It's a second court action to just discuss the damages. So, and we have the possibility in all cases to appeal. So there is one appeal to the Court of Appeals in the case of nullity actions at the federal courts, the Federal Court of Appeals, and in the infringement actions, the Tribunal de Justiça of the states. So it's possible to file a general appeal, and all the facts and documents and evidence can be reviewed by the Court of Appeal. And we have a third appeal after the decision of the Court of Appeals to the Superior Court in Brasília, that it's not a third instance, at least in thesis, and the Superior Court can only review federal law articles and violations of the law. it's not possible anymore for the Superior Court to discuss evidence or to discuss facts. So discussing or reviewing the conclusions of the expert, for example, shall not be allowed unless if there is a violation of the law by the proceeding at the expert proceeding. And finally, we have the Supreme Court in Brasilia also, only for the constitutional matters. So if a constitutional or any article of our federal constitution has been not been correctly applied by the Superior Court or the Court of Appeals or the judges. So only on constitutional matters. It's quite uncommon to have industrial property matter being discussed before the Supreme Court, but we have some cases. Recently we have a very well-known case discussing the limitation of the validity of the patents, and it was a very well-known case discussed 2 years ago at the Supreme Court that limited the extension of the patent to 20 years from the filing. So that's it. So you can cut, please. So again, thank you very much. And my purpose here was just to give a little bit of information on the Brazilian system and the differences that are quite important. So before giving the possibility of the people to give us their questions and suggestions, so if you want to have some comments on these differences, Ms. Friehe, it's up to you to start.
Just one thing about the Federal Supreme Court. As you said, questions of facts and questions of law. The Federal Supreme Court is usually only responsible for questions of law, not for questions of facts. One exception are patent nullity cases. In patent nullity cases, they are a second instance, and they are responsible for questions of facts and questions of law. And that was what made them take so long in earlier times for all the cases, because they also had to consider questions of facts. As I said, usually they don't have to. Like, for example, in infringement cases, they are third instance, and they are only responsible for questions of law. Sorry, this was all.
I have one question that was not clear for me. As we have a strong discussion in Brazil, if it's possible to sustain nullity of the patent within an infringement action. So, according to the German system, if there is a pending infringement action, so if the defendant the alleged infringer wants to sustain nullity of the patent, is he allowed to bring this discussion to the infringement action, or he must go to the federal courts and start the nullity action?
He must go to the Federal Patent Court. There is no discussion of nullity in the infringement court. He has to, if he hasn't filed a patent nullity action, the patent is considered as valid. So the infringement court has no right in patent cases to put into question the validity of the patent. The patent is valid. So if you want to have the patent invalidated, you have to go to the Federal Patent Court. It's a bit different for utility model cases, but they are special, so they are not in the nullity boards. And so I think this was a very short run through the Federal Patent Court and the patent nullity cases. We could talk about this for 2 weeks and not find an end.
And just to another question. So if the infringer wants to sustain nullity and then starts another court action against the patentee, the patent holder, what is the consequence for the infringement action? The infringement action will be suspended, waiting the decision on the nullity action, or it will continue, both actions will run together?
It depends on. So first, if the infringer started a patent nullity action and then withdraws, for example, his action, that's what I understood from saying sustained.
No, it's an allegation of nullity. If he wants to allege nullity.
Yeah, he can allege nullity only in the Federal Patent Court. So he has to sue for patent nullity before the Federal Patent Court. If this case is pending, he may ask in the civil court to stop the action, just to make a halt, just to wait for the decision of the patent court. And in most cases, in the cases where the infringement court thinks there might be a chance that the patent will be invalidated or partly invalidated, they will stay the infringement case and wait for the decision of the patent court. And that's where this indication is so important. This indication that we send is the essence of what the Patent Nullity Board, including the technically qualified judges, think of the nullity case right now. If the indication says no chance that the patent will be invalidated, the civil judge will not stay the infringement proceedings. But in the case when we say, okay, the patent will it looks as if the patent might be invalidated or at least partly invalidated, they will probably stay the infringement proceedings. And that's why it is so important that, for example, the fees are paid in time. They want to hurry up with serving of the patent action to the defendant, to the patent right holder, because only then can they ask the infringement court to stay the infringement proceedings.
Yes, we have a similar situation in Brazil. It's with a lot of controversy also, because we have this, if someone starts an infringement action, there is the discussion if the defendant may or not discuss nullity within this infringement action. Some decisions say that yes, it's possible for the civil court judge within an infringement action declare the nullity of the patent for the parties involved. And we have some decisions say no, it's up to the defendant to start a nullity action before the federal courts. And we have the discussions if there is this pending federal court on nullity matter, if it stays or not the infringement action. We have a term in Brazil that it's prejudicialidade externa, saying that in some cases it's mandatory to stay the infringement action in view of the fact that the nullity action may interfere in the decision of the infringement action. And for sure, if the patent is invalid, there is no infringement. And but in some cases we have some fraud from the defendant trying to postpone all the discussions and then not receiving a refraining order and gaining time and continue infringing within all these discussions. That's the point also.
Okay, of course, in the infringement proceedings, the question if they will stay the infringement proceedings has to be seen with a view to the chances of the nullity case. But this is only to be discussed if a nullity action is pending. Otherwise, of course, they would say there must be a chance that the patent may be invalidated. But the problem is, if there is no patent nullity case pending, there is no chance that the patent will be invalidated. Who will invalidate the patent? It's only the Federal Patent Court that can invalidate the patent. And the other thing, the Patent Office doesn't have a say in anything with us. It's a civil case between two entities, two parties. Yes. But the other thing, I just remembered this before. But the other thing is, there is no chance, that's something you have to bear in mind, there is no chance that the patent will be either wholly or partly invalidated if there is no patent nullity claim before the court. Because if there is no patent nullity action, the patent cannot be invalidated.
Yeah, okay, thank you very much. So perhaps I will start with our people here. If anyone wants to have some comments or questions, please feel free, in English or in Portuguese. E se tiver alguém também da audiência do virtual que quiser fazer pergunta, pode fazer. Nosso apoio aqui tecnológico é de primeiríssima e podemos responder para vocês. Tá? We have one question here from our president.
I'll just start by asking Mrs. Friehe to tell us a little bit about, if she can, of course, because I know she was a judge in annulment proceedings, but she can tell us a little bit about infringement, especially the choice of venue. I know that in Germany, Dortmund, especially Düsseldorf, they're close. Düsseldorf is especially well sought as a favorable venue for patentees to act against infringers or alleged infringers. Why is that, and what do you think about that?
I think it's depending on the expertise of the judges, and this is if the judges have a lot of cases, for example, a lot of patent infringement cases, they get more experience, and if they are very experienced, they get more cases. So I think in the whole of Europe, 60 or 70% of all patent infringement cases are in first instance in Düsseldorf District Court. We also have some cases in Mannheim, in particular if we are in information technology, etc., computer technology. We have some cases in Munich and some cases in Hamburg. I think in Hamburg it degraded after my travel companion was presiding judge in the infringement board in Hamburg. Until he retired about 10 years ago. And at that time they had more cases than Munich, but now Munich has more cases, Munich District Court. And it's just the experience they have in this field, and Düsseldorf is very experienced. So, well, it adds to their experience. So you would go to somebody who knows what he's talking about, so you go to Düsseldorf. The next one says he has even one experience more, so he goes to Düsseldorf too. And there are a lot of patent attorneys and attorneys at law specialists in patent law with their offices in Düsseldorf and lots in Munich. And there are some more, like, as I said, Mannheim, which where the second instance Karlsruhe, where the Federal Supreme Court is also seated, and we have some in Munich or in Hamburg.
Thank you. I'm seeing that we have one question here.
Just a quick question about the UPC. I would like to know your view about the UPC, the Unified Patent Court, and how it would affect, if it affects the German patent courts.
Yeah, at the moment it hasn't yet started, to my sorrow, because I applied to and had a good chance until last December, because in December I was 67, so I was over the limit. They want to start in June, as the last thing I heard. We will see how they work, because I think this problem is the same as in Germany with Düsseldorf, or maybe you wouldn't go to Bamberg, even if there is district court too. Okay, I think Bamberg is not, maybe they are even responsible, but we have a concentration on some courts concerning patent cases, but in Germany. But anyway, you would go to an experienced court. You will have to see who is experienced in the UPC. I suppose by the nature, because you can you can stay with your patents in Germany for 7 years, and I think then again 7 years probably. But in the end, most of the European patents will go to the UPC if the UPC is successful. How successful they will be, I don't know, because they haven't yet started. But I think as to the people I know who go there, like Dr. Krabinski, for example, who's going to be the president of the first first instance court, he's extremely good. I don't know, to bring a professor of law who has very few experience in patent cases to the Court of Appeal, I don't know why. But, and anyway, I don't know the people from other countries, because I think Germany has 60% of infringement cases in the whole of Europe. And anyway, at least after UK has left the European Union, because they were also very experienced, but there are other countries, like for example France, who grants patents without a thorough examination. So this doesn't give a lot of experience to the people working with this. I think it's we will see, and it's difficult to say how successful they will be. I hope that they will be, because it was high time that Europe got a court. It was too late for me, but anyway, they were when I came to the to work at the Federal Patent Court in the end of the 1990s. They were already discussing, and I think it was a second try, how to build legislation, or not a jurisdiction, a European jurisdiction on patents. But now they finally succeeded, and I hope that the court will be also successful.
Go ahead.
Do you think they will be more careful than the German patent courts to not invalidate patents in the start, so to not scare the European patentees?
I hope they won't, because we are careful too, and I think if you read statistics that say 70% of the patents are nullified, which is not true. Because they count into the 70% also the patents where only a tiny bit is invalidated. So if you calculate 70% including the tiny bits, it's a bit difficult. I would say 1/3 are invalidated, 1/3 are not invalidated, and 1/3 are partly invalidated, more or less. Because we also reject claims of nullity, and you see, it is very expensive. You only claim invalidity if you think you have a chance, because you spend a lot of money on it. And I think I know some of the colleagues, or technically qualified colleagues, who are going to be members of the UPC, and two of them were in my board, and one of them was a woman. I think she was the best I ever saw. She's fantastic. So the other one is good too, but she is really absolutely fantastic. And so I hope that the other technically qualified judges are also very good. And this is the same as, of course, court experts. You usually follow the court experts, but you don't have to. With the technically qualified judges, the people, the parties never know, because we deliberate behind closed doors. We talk about everything, and I think every one of them has a say. It's not, they don't give their opinion and leave it to the lawyers. No, in our court they are judges. They are professional judges. They deliberate together with us, and they vote. They have the same vote as I have, even if it's just a question of law. But I have the same vote if it's the question of technology. And I'm a lawyer. And okay, I studied mechanical engineering. I wanted to be an astronautical engineer when I passed school, when I finished school 50 years ago. It's really 50 years ago. What we did is information communication technology and medical technology. I didn't study that. So, I was not an expert in those cases, not at all. I wouldn't have been an expert in mechanic. So, okay.
No, thank you very much.
Okay, thank you.
So it's interesting, as you mentioned, because in Brazil we have both in an infringement action and nullity action, one judge granting the decision. It's just one, and with law background. And if there is an appeal, the Court of Appeals, there are 3 judges, panel of 3 judges, but all of them with law background. So using them, all the technical evidence produced within the proceedings. But for the unified patent in Europe, just one clarification for our audience. The Unified Patent Court will deal only with nullity or with patent infringement also?
Both. Usually they will have patent infringement, but you can also either file for nullity, then it will go to the central division. And there are 3 parts of it. One will be in Munich, in the rooms of my earlier court, and the others, I suppose, will be in Paris, because London then went out. Yes, and you can also counterclaim for nullity. So then it might stay with the infringement court, and the infringement court may ask for an additional technically qualified judge. I hope that they will do, because they would be well advised. Because I think it's hybrid. If, as a lawyer, you think you can do the technology just with your little finger, it's no, not possible. So I hope that they will take the chance, and if there is a counterclaim for nullity, they will ask for an additional technically qualified judge.
Thank you very much. We have one question from Marcos Blasi.
Hi, thank you very much. Just a quick question and a quick comment. First of all, thank you very much for our very instructive and informative presentation. It's really enlightened us with your knowledge and experience. And as the ABPI local representative here in São Paulo, it's an honor to have you in person with us in our home. So thank you very much for that. Just a quick question. In terms of numbers, the federal court, the Federal Patent Court, on average, how many cases it receives and judges per year? Just a general average.
I read
so much.
Some days ago that in the beginning of this year, the court had 99 judges. So about 100, more or less. I think something between 55 and 60 are technically qualified judges, and the rest is legally qualified judges, lawyers. I don't know the numbers of the technical cases, technical appeal board cases, but the nullity cases were, I think, in the highest, they were about 300 for, at that time, 6 boards. But 50 to finish 50 cases per year is a high number. I know because we usually did 50 to 60, and people were very angry, partly because they used to say that a patent nullity board cannot finish more than 30 to 40 cases per year, and every year we did 50 to 60. But this was because my people, my boys, boys and girls, they were very, very hardworking, and I had really very good people in my board, and I had very nice people in my board, and I was very keen not to neglect them. And when they worked hard, they put their votes on my desk, and they expected me to put them in, get them into indications as soon as possible. So I had to work a lot too. And if I did so, they were happy and they worked even more. So that was, and then we had some cases that we combined because, like for example, car manufacturers who didn't realize that they were infringing information and communication technology patents. Like nowadays, a car is a rolling computer. And that's what they did not expect. In earlier times, they had, for example, a patent for part of the engine or a patent for another technical part in the car. Now they are infringing patents of mobile telephone producers, and they don't want to accept that they are. They didn't want to accept that they are infringing patents of a technology that is quite different from their origins. So, well, and we had lots of cases. We had lots of cases of different car manufacturers against Nokia or against Ericsson or so, and we combined them. And so we had one oral hearing and one judgment, and we had 2 or 3 cases closed. But anyway, these cases were longer than and bigger than an ordinary case.
Yeah, very interesting. But this point brings me to another question. In a general average, what's the timing of a nullity action from the beginning to the decision in first instance? It will take, in general. Yeah, this is different now because they speeded up the procedure. Usually the indication has to be filed upon the parties, served upon the parties within 6 months or so after the action has been served upon the defendant. But so then, after the indication, there is some time. There are some time frames for additional submissions, but usually you would see that you could get the oral proceedings as soon as possible afterwards, because otherwise, if they don't respect the time limits, but anyway, there is still half a year between their submission and the oral hearing. There is no way to say the other party didn't have the time to answer it, and we didn't have the time to prepare. So they will ask to close the case as soon as possible. At earlier times, we were a medium fast in our board, perhaps a bit faster than medium. I think that mostly we finished the cases in 1.5 years or so. But there were cases where, well, sometimes for
personal reasons, for example. The mother of one of my colleagues had cancer and she was very sick, so he could not really concentrate on the cases and he was late with cases. Things like that have to be respected, and it doesn't help if he cannot concentrate on the cases and takes longer. It's no use to tell him speed up and send me anything, because it's no use if I cannot rely on what he wrote. And sometimes it takes 3 years or 3.5 years, and sometimes even before a year we have finished. We have one colleague, he did the classical electrical things. He was so fast that we concluded the cases in his field of IPC classification within maybe sometimes 8 months or so. But he was very, very fast, and he had the classical electrical engineering, and this is not, those were files like this, otherwise we had files like this. So this is different, and well, so to say within this time, I don't know, it's very difficult to say. What's strange was that there was some time where the appeal cases took longer than the nullity cases, although the appeal cases are much less work. But sometimes some appeal boards didn't work so much on appeal cases because their people were working on nullity cases, I must admit.
No, it's we also understand that it will depend on the you have more simple cases and more complex cases, it can last longer, but 8 months is a dream for us.
Yeah, but it's only this colleague. Jochen was a very fast worker, very experienced, very fast worker, and he had the easier cases. Because he's a classical electrical engineer, and he was not a rapporteur in those difficult cases. He sat in them sometimes, but he was not the rapporteur.
Do you have any other questions from the audience? I have some questions from... No? So I have one last question. The post-grant opposition. We have in Brazil also a post-grant opposition, like in the EPO. According to my recollection, the EPO, it's up to 9 months from the granting. It's possible to start the post-grant opposition. The post-grant opposition in Brazil is named Processo Administrativo de Nulidade, PAN. It's 6 months from the granting, the final deadline. And you said that if there is an opposition pending, it's not possible to start the nullity action. And in Brazil, yes, we can start the nullity action, even if there is a Processo Administrativo de Nulidade post-grant opposition pending. And we have different decisions. Some of the if there is a pending post-grant opposition, and if there is a nullity action started thereafter, the Brazilian PTO will have the possibility of staying the post-grant opposition or not, depending if it's the same parties involved, the same arguments, etc. So we have conflicting decisions from the PTO staying or not the post-grant opposition. But according to the Brazilian law, it's possible to start the nullity action even if there is a pending opposition.
Yeah, in Germany it's different. We have the right for the opposition. Earlier, for the Patent Act, we had only 3 months from the mention of the grant, from the day of the mention of the grant of the patent. Now we have 9 months, and this has been for some years, maybe the same as the indication, 12, 15 years or so. We have the problem is that another infringer, for example, who did not file an opposition and the opposition time frame expired, would be without any remedy against the patent right holder, and therefore he can access to the opposition proceedings, even to the opposition proceedings of somebody else, and in any instance. So even if it's in second instance, he is opponent, not appellant. In an appeal case which is pending before the Federal Patent Court, for example, in the opposition appeal case, and there is a new person, entity who is who sued for infringement, he can adhere to he can enter the appeal case as opponent. But I think for him the time frame was not extended to 9 months. It's still 3 months. 3 months from the, for example, from the serving of the infringement action on him. And I think that was one of the first things I had to do when I came as a lawyer to a technical board of appeal, check when were the additional infringement actions served on the additional opponents.
Okay, thank you very much once again for your time and for the very interesting presentation. Thank you, the audience, for participating and hearing us. I don't know if our president would like to close the audience. Thank you very much.
Muito obrigada.
I just wanted to say thank you again, Mrs. Friehe. For those who do not know, Mrs. Friehe is in vacation here in Brazil, but she was kind enough to give us a few hours of her vacation. And we are being very punctual. It was foreseen to start at 9 and to finish at 11. So thank you for all of you at home or in your offices watching this presentation. Everything was recorded, so if you enjoyed it, you may tell your colleagues in your firms that they may watch it later on. So Mrs. Friehe, ABPI is always at your disposal. I hope you have a wonderful vacation continuing your trip here in Brazil. Thank you very much.
Thank you very much to you, and I think you saw that I'm really an addict.
Muito bom. Então, terminamos. Obrigado, gente. Obrigado, Jacques Labrunie, novamente, né? Mas o Jacques é da casa e foi muito generoso ter vindo aqui também receber a doutora Friehe. Obrigado, Jacques. Muito bom. Até a próxima.
A propriedade intelectual é responsável hoje por até 80% do valor das empresas. Mas isso não acontece apenas porque as empresas dão valor à sua propriedade intelectual. A propriedade intelectual vale muito porque a sociedade dá valor ao esforço de solucionar seus problemas e de lhe criar oportunidades. Nosso congresso desse ano vai reunir especialistas em propriedade intelectual, juristas, economistas do desenvolvimento e da inovação para nos guiarem nessa importante discussão. O pano de fundo escolhido não poderia ser melhor: as maravilhas da cidade do Rio de Janeiro. Para comemorar seus 60 anos de existência, a ABPI reunirá os participantes nos mirantes deslumbrantes do Pão de Açúcar, ícone turístico do Rio de Janeiro, aclamado por visitantes do mundo inteiro. Durante 3 dias, teremos a oportunidade de nos encontrarmos, fazer negócios e, sobretudo, de discutir e aprofundar nosso entendimento do papel da propriedade intelectual frente aos desafios brasileiros. Da consolidação do agronegócio ao desenvolvimento do turismo e de indústrias avançadas, da transformação digital e da transição energética ao estímulo ao empreendedorismo e à inclusão social. Participe e se engaje com o compromisso social do Congresso da ABPI de 2023. Esperamos vocês de 20 a 22 de agosto na cidade maravilhosa do Rio de Janeiro.